You know we go hard in the paint. We're back for our fourth video today, fifth video today, whatever it is, because we've got big news. Of course, we've got a legal expert on here to talk about exactly why you need to watch Jimmori Robinson and company have a great shot to be eligible. And we got somebody that's going to explain it right now.
You are Locked On West Virginia, your daily podcast on the West Virginia Mountaineers, part of the Locked On Podcast Network, your team every day.
What's up, guys? Welcome back in. My name is Mountaineer Paul. I am your host. This is Locked On West Virginia, baby. Well, we're back again for another episode for you today. I'm going to be brought to you by Game Time, of course, guys. And when we talk about Game Time, we talk about doing a big, of course. Why? Because right now with the Game Time app, download an account, use code Locked On College, and you're going to get $20 off your first purchase. Thank you guys so much for being here with Locked On West Virginia, where we talk about your single team every single day. Of course, we talk about the Mountaineers around here, and we're grateful to do so. But I'm not alone. I bring great joy, hopefully, to you today. Somebody I'm excited to bring on, somebody that knows a lot more about this stuff than I do, as I was just guessing and using AI. How about we use somebody that knows exactly what they're talking about? What's up, Sam? How you doing?
Hey, Paul. Thanks so much for having me.
Yeah, man. So this is in a unique situation. Obviously, number 30 against the NCAA. So not so unique when it comes to the NCAA. And they've been really damn good at winning these cases. At about 80-something% or something in that range?
Yeah, that might be overstating a little bit. There's been kind of some mixed results. It's not clear kind of wins and losses, but they've definitely been winning more than they've been losing. That's for sure.
Which is not par for the course in them usually.
It really is. I mean, especially with the field of law that we're talking about, antitrust law. I mean, this is exactly what led to kind of the demise of the transfer portal, as West Virginia fans very well know, with Raycon Battle. This is what led to, the Tennessee lawsuit, of course, where it abolished the NCAA's prohibitions on pre-enrollment recruiting. And of course, Alston, House, O'Bannon, all those cases were antitrust law. This is no different. This is another one of those antitrust law cases that the NCAA has been very plagued with. And that's why they're looking for some kind of exemption from Congress.
Do you know where Sean Alston went to college?
He went to West Virginia.
West Virginia is going to single-handedly bring down the NCAA.
You guys in Tennessee.
Tennessee.
1-2 punch, and the NCAA is not, I can't imagine their legal team is particularly fond of you or Tennessee at this point.
Don't mess with Appalachia, bub. So obviously you're in Boise. I just came through around near there. How come nobody told me the elevation was going to suck?
It's real high up here. It's real high. It's real north up here. In fact, it's 8:30, about 8:30 right now, and it's still bright as day outside.
Oh yeah.
Right, so it's pretty great. But yeah, the elevation. I was just in Rhode Island last week actually, and I'm still kind of feeling it a little bit going up and down.
Yeah, we came through Denver. It got like 12 or 13,000. I was like, I can't breathe. I'm already big. So as far as this case goes, and this is kind of what I was able to figure out, based on your tweet, you were talking about, obviously the fact that Judge Klee has recused himself, citing his support of West Virginia athletics. Mm-hmm. Judge Bailey steps in, who obviously the year-in residence transfer rule, which was also violating antitrust law. How similar are these two cases?
Yeah, this is not a courtroom the NCAA wants to be in, because they're different in some ways. I mean, obviously they're different NCAA rules. You have the transfer portal, which is much broader. You had, for example, Raycon Battle was kind of the first one to lead this case, but the eventual case that eventually led to the end of the transfer portal was actually led by the state attorneys general of Ohio, West Virginia, a bunch of other states alongside that, including the federal government, the Department of Justice.
Our current governor, Patrick Morsi.
I'm sorry?
Sorry, our current governor was part of that, Patrick Morsi.
He was. He absolutely was. And that's really what, I think in a lot of ways, the attorneys general getting involved in that case was a big part of it. But, I think we're seeing with all these cases, I mean, you're seeing a lot of back and forth. And I think there's really two really key things about the fact that this is now in Judge Bailey's courtroom. because there are two things that have kind of distinguished wins and losses for all these different eligibility cases. At the end of the day, there's been two reasons why the NCAA has been able to win these cases. For the most part, there's been a few isolated exceptions, one of which is finding that the eligibility rules are not commercial and thus not subject to antitrust law. And the other is finding that there's just not enough evidence to have a preliminary injunction, a high standard of a preliminary injunction. And here, Judge Bailey has already ruled that similar rules, the transfer rule, even if it's not exactly the same rule, was commercial, was subject to antitrust law, and ruled that there was enough evidence to give a preliminary injunction. So that's two pretty big indicators right there that Judge Bailey is, I think for a lot of these cases that are a little more unpredictable because you don't know what the judges are going to rule. Here we have a pretty good idea of how Judge Bailey might see this case.
And so when judges rule a certain way, historically, or however you want to put it, is that considered like, okay, like in other words, like if I vote Democrat or Republican, that's kind of like, that's in my file or whatever. Like, is when judges rule a certain way on certain things, is that something they build on?
Yes, absolutely.
You know what I'm trying to say?
Yeah. No, I know exactly what you're trying to say. It's actually the fundamental part of our legal system is precedent. Is the idea that, one judge rules one way, and as long as it's binding precedent, or even if it's persuasive precedent in some cases, other judges are going to want to rule the same way. They're going to want to stay consistent. And these eligibility rules have been anything but consistent, in part because I think judges are kind of seeing the landscape a little bit differently, where some are deferring to precedent prior to the Sean Alston case, prior to 2021, prior to NIL, which kind of held this kind of greater reverence for amateurism. And obviously now we're in a very different landscape here. Some judges are recognizing that, some are not. And I think, what's fortunate for West Virginia fans right now is that Judge Bailey, we already know he recognizes that there's a big difference here, and that difference should be reflected in the way the law is handled.
Yeah, this is definitely an interesting thing. I'm also curious, is there possibility that this could go to a higher level of court beyond this, or would this be the end all be all? And also, being that this is so close to the season now, let's say he gives them the injunction, would the NCAA even have time to counter because they're already going to be playing?
Good question. And, first, to answer your first question, if the West Virginia players end up winning this, the NCAA is absolutely going to appeal this case. That is absolutely a for sure done deal. All the cases that they've won, or all the cases that the players have won so far, the Diego Pavia case, the Jet Elad case, the Nizer Forquellen case out of Wisconsin, where the NCAA already got that reversed on appeal. The Cortez Brom Jr. case out of Nevada. Every single one of them, the NCAA has appealed it, and I would not see this as being any different. Appellate courts do move pretty slowly, though. I mean, they might grant some kind of expedited consideration, but they did in the Elad case, and that was decided back in March by the district court. We still don't have a decision from the Third Circuit. We don't even have oral arguments from the Third Circuit on there. So it'll definitely take some time for the Fourth Circuit Court of Appeals to hear this if the West Virginia players do end up winning.
But if they're already playing, I guess at that point, like, it feels like, how could they say you can't play? I'm very confused, like, if they were already playing, then what would be the point in appealing it?
Yeah, I mean, if the appellate court finds that the preliminary injunction was improperly issued, was not issued for a correct reason, they can certainly pull it. They can certainly kind of reverse it, but it might be something that the NCAA kind of considers in it, where it's like, okay, what's the point to do this, though? I think the NCAA is also very much wants to not set a precedent on this. That's why they're appealing all the other cases as well. Right. So they'll appeal it. It may not even matter by the time that the appeal is even heard or decided, but I would fully imagine that they would appeal it.
Okay. Let's go to break really quick, guys. We'll come right back. We'll finish up with Sam. Got a couple other questions for him. Stick around. This is Locked On West Virginia. And this episode of Locked On West Virginia going to be brought to you by none other than, of course, we're going to talk about 5 Hour Energy, guys. And look, talking about 5 Hour Energy, there's a couple things you need to know. If you want to fuel up with a 5 Hour Energy transfusion, and you want that bold, grape, ginger, and lime flavor in your golf drink, minus the alcohol, into a quick, energizing shot, well, I do too. And whether you're sinking birdies or just making memories with friends, There's a hole-in-one out there for you for your energy game. And let's be honest, some days on the course or off of it, you just need that extra boost to stay sharp and energized. Go to 5hourenergy.com today. That's the number 5, the word hour, the word energy.com, so you can use my promo code LOCKEDONGolf for 20% off your first order. This offer is only going to be valid until September 30th on one order and cannot be used with other promotions. The code is also not going to be good on subscription orders. Thank you guys very much. We'll be right back. All right, and we are in segment 2 where, Sam, we always crack a do. Do you have a do beside you, man, or what?
I don't. I just have a thing of water, unfortunately.
Look, they always tell me I should move on from the do. It's like my only vice in life now and more anymore. But yeah, this is going to be interesting, guys. So we obviously talked about Judge Bailey, the whole thing. So can we just talk a little bit more about what it is that they're saying is antitrust?
Mm-hmm.
Basically, they're saying, okay, you're telling me that inside of 5 years, I'm supposed to get, and we've had all these things happen. All 4 players were in JUCO in or around COVID, right? So you've got COVID years that weren't played. You've got the Diego Pavia rule. You've got guys that have been medically redshirted. You've guys that have naturally redshirted, and you've got both in all these cases. It's a very convoluted, right? And when you look at it from that perspective as well, how can you ask these kids to get, in these cases, all that done inside 5 years?
Yeah, and I think from an antitrust perspective, antitrust law is all about competition. It's all about economic competition, not on-field competition, but competition between businesses, between sources of labor, for example. And it's all about kind of protecting against restrictions on the ability for people to enter into certain markets or compete in certain markets. Same kind of law that governs that prohibits monopolies, for example. So here, like let's take a look back at Diego Pavia, because Diego Pavia was really the father of these cases. He was the first of these cases and the one that led to the other 29 cases that we've seen since. Diego Pavia argued that the eligibility rules were a violation of antitrust law for 3 reasons. One, they restricted his ability to earn NIL compensation, to be able to profit off of his name and likeness as a college athlete, where yes, he can enter endorsement deals after, but it didn't have the same kind of value because he wasn't going to be a Vanderbilt Commoner anymore. He was going to be, well, let's face it, probably on a practice squad in the NFL somewhere. Good player, maybe not NFL player. 2, he also argued that, well, with the incoming House settlement, it would restrict his ability to make money in terms of revenue sharing dollars, in terms of the dollars directly from the school. And 3, and this is kind of the kicker, and this is really what's kind of distinguished JUCO, why the JUCO part of it's so important. He also argued that there's actually competition between the NCAA and the NJCAA, the Junior College Athletic Association, for players, for labor, for college athlete labor. And he argued that, well, by counting JUCO years as the same as college athlete years, or the same as NCAA Division I years, it was actually disincentivizing athletes to go to junior college. It was providing restraint on the market in terms of the junior college's ability to compete. In fact, the junior colleges were thrilled when the Diego Pavia ruling came out, because if it ends up going further, if it ends up becoming a permanent rule where junior college doesn't count towards Division I, well, there's going to be a lot more incentive to go to junior college because it wouldn't count towards Division I years anymore. So that was the rationale that Pavia was able to give, and that Judge Campbell in Tennessee ended up deciding in favor of it and ended up saying is correct. And in fact, I know it because I read the complaint. The 4 West Virginia players are making functionally the same argument that, yes, we have the Pavia rule now, but now we have the 5-year clock that's being enforced them as well. It's not just the 4-season rule, it's the 5-year clock. Yes. And that is, too, the same kind of thing, the same kind of restriction.
And so can we kind of talk and dig into a couple other things? The difference between the pride of place and the essential facilities doctrines, because pride of place is basically saying, hey, look, it's very obvious that you favor these universities over JUCO, right? Or wherever.
Exactly.
and like look at all the amenities they have. We're not even associated with you, NCAA. So
Mm-hmm.
why are we held to this clock, right? Is that a part of this argument?
It
And
is.
with the essential facilities, is that saying basically like you're a monopolist kind of regime with the NCAA that is
Not
basically
exactly.
okay?
So the pride of place argument, you hit the nail on the head, and that's exactly what I was just referring to with the junior college argument, where
Right.
you're favoring NCAA schools, your schools, the schools that are within your association, over junior college schools by giving priority to them by allowing junior college years to count the same as a Division I year.
And the GPA thing.
Exactly. That's a big part of it as well. In fact, I've seen athletes who have, some of the athletes within these 30 cases have actually, challenged that rule specifically, saying that it is also a legal restraint on commerce. And the essential facilities doctrine, the best way to describe that one, I think the best example for that is back in the 80s, there was a lawsuit between the NFL and the USFL. The very famous one that ended up with USFL. The USFL ended up winning the case, but they had already moved to the spring, so they didn't suffer any damages. So they got $1, which was tripled to $3. So big win for them. But what they argued based on the essential facilities doctrine, where the NFL was signing exclusive deals with stadiums, they were signing exclusive deals with television networks that really kind of muscled out incoming leagues, the competitor leagues like the USFL, that look to compete with the NFL for eyeballs, for players, for everything else, where they would have to go to inferior stadiums and be on inferior broadcast companies. That's what the essential facilities doctrine is that one company it is kind of in that kind of monopolization standpoint, but it's going to be in Section 1, so it's going to be multiple parties. But it's very much going to be like you are trying to muscle us out.
You're
of that
denying we're not getting access.
Exactly, and that's what these players are arguing. They're saying you are muscling us out of here by kind of holding us to 4 seasons in 5 years.
Very interesting, man. Very, very. I appreciate you breaking this down for us.
Of course.
Yeah, because you have to at least there has to be some how do they say it? Some feasibility of access, right?
Mm-hmm.
So
what's going to be really interesting about this is that antitrust cases are evaluated on the rule of reason, and the rule of reason is all about balancing anti-competitive harms against pro-competitive benefits. And the anti-competitive harms here, I think, can be fairly easily argued. Some judges are saying, it's a little harder to tell, but the pro-competitive benefits are really kind of what is going to be interesting here, because the NCAA is hanging firm to the idea that the fact that this is college football that's tied to college player status is a real big pro-competitive benefit here. So the challenge is going to be for the plaintiffs, and we've seen this in a few different cases, is really articulating what the better way of achieving those pro-competitive benefits are, because that's step 3 of the rule of reason. Being able to say there's a better way of doing this. There's a less restrictive alternative to these pro-competitive benefits. And that's why a lot of the judges in these cases have been saying, well, where does this end? Like, are we going to have a rule? Are we not going to have these rules at all? And none of the plaintiffs are arguing that. And they're being very smart in doing so. They're saying, don't allow just don't have JUCO. That would be a less restrictive way of doing this. You can still have 4 seasons in 5 years, just limit it to Division I, or limited to you get your full undergraduate plus a graduate year, and however long it takes you to complete that, as long as you're making progress, that's a way to do it. So we'll definitely see how that pans out. And I think the appellate cases and the Pavia case and the ELAD case and the Brom case are going to be really, really telling on that.
Is this something that could extend one day to? I've always wondered this, and you're the perfect person to ask. Mm-hmm. If the SEC and Big Ten were to ever decide to take their ball and go home, do you foresee this happening with the other major ACC, Big 12? Do you think they would sue the other conferences for basically saying you're restricting our access? Do you think 1, this would go down that road? Yeah, this would happen.
1,000%. And that also applies to if the Power Four, the Big 12 and the ACC are part of it. I don't think I'm breaking any news here by saying that. I think Boise State not thrilled about that.
No doubt, man. No doubt.
So maybe I'd be
as it stands
me
now,
personally, but
everybody has a seat at the ultimate table, right?
Mm-hmm.
And that's how it should stay. Mm-hmm. That's all anybody ever wants. How it's all broken down, how many seats somebody gets, that's definitely up for argument. At the end of the day, as somebody that's I mean, we grew up in the BCS era where there was only one seat, really, if you can, so I mean, I remember we watched as well. I mean, you go back to 2007, Pitt beats West Virginia 13-9. We got knocked out of the national championship game. Ohio State plays LSU instead, right? We saw that happen. We had a chance, The illusion of that chance is all I really care about.
Yeah, and I mean that same year is the year that Boise State beat Oklahoma in the Fiesta
That's
Bowl.
right.
Several years after that,
Boise
State felt that they should be competing for a national championship, and they were never given the opportunity.
Yeah, man. So before we go here, let's go to one more break. When we get on the other side, what we'll do is talk about some places people can find you, and we're going to pull up the little charts I have for all these players and just kind of look over just how crazy they're. I mean, they've been nomadic, to say the least. We'll be right back. And this episode of Locked On West Virginia going to be brought to you by, of course, where are we at? Monarch Money. That's right. We're looking at Monarch Money, guys. We love Monarch Money because at the end of the day, man, you got to control your finances. And if you've ever wanted to manage your money with more ease, Monarch Money can help you do that. Whether you're growing savings, planning a big purchase, or what have you, Monarch Money puts you in the driver's seat. It's your own personal CFO giving you full visibility and control of your finances. It's more than just a budgeting app, though. It's a complete financial command center where you can track all accounts, investments, and spending in one easy, convenient place. So in addition to managing your money, you're also building your wealth. Take control of your finances today with Monarch Money and use code LOCKEDONCollege at monarchmoney.com for 50% off your first year. That's monarchmoney.com, code LOCKEDONCollege for half off your first year. All right, guys, we are back here in Locked On West Virginia with Sam. Is it Ehrlich? Ehrlich. Sorry, guys.
No problem.
Where can everybody find you, man? I know you had mentioned a website, a Twitter account.
Yeah, excuse me. My Twitter account is Sam C. Ehrlich. I'm pretty active on there. Usually talking about these eligibility rule cases and seeing what I can, find in these filings. So feel free to follow me on there. I'll definitely have updates on these West Virginia cases as they come. I also run a website, collegesportslitigationtracker.com. Probably need to find a shorter way of doing that, but that's what it is, at least for now. Yeah, collegesportslitigationtracker.com. And I'm tracking all of the litigation involved in the NCAA right now, or at least as much of it as I can find, including all 30 of these eligibility rule cases, which has been not exactly what I signed up for when I created the website, but it's been a lot of fun and very, very interesting to follow.
Is it growing?
It is. Yes.
Awesome. Congratulations, man.
Thank you.
I've got those in the comments here. It is like 11 o'clock here. So I was, not as many people as I thought were going to turn out. We still got quite a few people if you consider X, YouTube, the other places, but still, I had just got done with the video. So, but yeah, everybody that's in here, make sure you check out Sam. He does an excellent job over there and is the reason I even know what I know. So, last couple things we want to do here is I'm going to share the screen here, Sam, and this is something I had Grok make for me. Probably a couple weeks ago anyway. You look at these specific cases like Jimmori Robinson, 19 and 20, he was at Dodge City Community College. 2021 academic year, he transferred to Monroe. 2021, 2022, he enrolled at UTSA. But if you look closely, he didn't compete in the 2021, 2022 year, the 2020, 2021 year. In 19 and 20, he was in JUCO. Like, would you say of all the people, like I've heard people say of all four players, his looks the best? Have you looked over the specific cases?
I have, but I haven't really paid that much attention to actually the year by year because honestly, for this kind of argument, for this antitrust argument, it doesn't even matter all that much. Like it definitely matters to the NCAA. It matters very much to the NCAA in determining whether they're eligible for a waiver or if they fit into the Pavia waiver, for example, which is limited to players who haven't exhausted their 5-year clocks, including a COVID or plus a COVID year. But to a judge evaluating this antitrust argument, how much they've transferred, how often they've transferred, the different places they've been, that actually hasn't really mattered all that much at all. Judges have not really limited themselves to that or really analyzed that as part of the argument because it's really an antitrust argument.
Yeah. Okay. Gotcha. Makes sense. I guess what I was looking at more so is just, I mean, it's just almost like, like in his situation, if it wasn't for the 5-year clock, technically he'd be eligible because up to 2 of these years he hasn't been able to play due to whether it was COVID year or an injury or whatever, what have you. In almost all these situations, if they weren't held to this 5-year clock, they'd be good to go.
Exactly. And we've actually seen that in a few of these different cases. And it hasn't even just been, well, they've been sitting on the bench. They haven't been able to play. Because I think that may be, just policy-wise, not legally. It doesn't really matter as much legally. But policy-wise, it may not be as strong of an argument because, yeah, they weren't on the field, but that's coach's decision. Maybe they just weren't good enough to be on the field at the time. Maybe they were just working up the strength or something like that or working up the skills. But there's been actually a few of these cases where the players have said, hey, I had family situations. I wasn't even enrolled in school during this time, but because I started my college career the year before, you're counting that towards my 5-year clock, and that doesn't make any sense.
Wow. It's just so arbitrary. Like,
it
makes no sense, man. So, yeah, but if you look at the rest of these guys, I mean, Justin Harrington's what a career, started in 2018, So, I mean, obviously as a college football fan, my last question to you is this, Sam. I mean, you're a college football fan as well, correct?
Oh, yeah.
So how do you feel about this personally outside of the legalities of this? If this is to go away, what do you think it does to the sport? I mean, obviously the ceiling gets way higher, right? Is there a limit at that point?
I do have mixed feelings about it because I do fully understand and empathize with the arguments of college football fans saying, hey, this is college football. There should be college students playing it. I mean, if you're having, older players who, are doing this just because they can't play in the NFL, it kind of destroys the integrity of kind of what the game we love and the
That's
idea
a very
that this
good
is,
point.
again, a college sports. But I put the onus on the NCAA. The NCAA needs to have, and I'm going to use the exact language from the Nicer footballing case from the Western District of Wisconsin, the Wisconsin player who was initially granted a preliminary injunction and had it overturned on appeal, but there's going to be a very quick trial there, so that may reverse again pretty soon. And what Judge Conley in that case really talked to is said the NCAA needs to have meaningful exemptions here. They need to actually take these waivers seriously. They need to not stall for time in all these different waivers, just so the legal case looks worse. Or they need to actually really consider the particular situations of these different players, or just have a straight 5-year clock, or just have it be very kind of simple, be very straightforward, and not have all these different exemptions that are very arbitrarily applied. It's really the arbitrary nature of this that really kind of bugs me and really kind of gets to me and really makes me emphasize with the players a lot more, because the players are confused here. I get DMs, every few days from players who are in similar situations. They're like, I don't understand why I'm not in this situation, why I can't get this kind of relief, because I had all these different things happen to me. I was just talking to a player earlier today who, was in a situation like this. And the NCAA is just so inconsistent about these waivers. That's what really gets to me. And that's what really, again, makes me emphasize with the players in this case.
The NCAA is the equivalent of the trust fund baby. That's how I look at them. They're a trust fund baby. They don't, it's almost like they don't care or respect what they have or are in control of, and are totally out of control. Is it still? I don't even know who the president is anymore. Is it Baker still?
It is still Baker. Yeah, Charlie Baker.
I mean, at a certain point, I think you just have to realize it's a good old boys network there, and the way they do things is probably not how the NFL does things. Who does almost everything right. So I know I said last question, but I do have one more. How do you feel about another entity controlling college sports outside of the NCAA, like, either Nick Saban or even better for college sports, Cody Campbell?
Cody Campbell doing it would be very interesting.
Yeah.
Very intriguing idea. Some ideas I'm not huge fan of, but he definitely is a lot more for the kind of broader inclusiveness of college sports. To actually have it be broader than just, the Power 2 or even the Power 4, which, I'm as a Boise State fan, I'm definitely in favor of that component to it. I think it really depends on who's running it. I think it depends, and not even just the person in charge, because I think you can even question, you didn't even, know who the president of the NCAA was, for a second. You weren't sure if it was still Charlie Baker. And I think that just goes to show the president of the NCAA, they're kind of just a figurehead at the end of the day. I mean, Baker was really just hired to, kind of lead the lobbying efforts. He's kind of the lobbyist in chief for the NCAA in a lot of ways. And that's
lobbyist in chief.
I can't take credit for that. I can't remember who said that originally, but and that's not to minimize, all the good he's done, and that's not to minimize the role he's had with the NCAA. It's just the NCAA is the schools. The NCAA is the collection of presidents and athletic directors who have the voting power, have the seats at the table to create this legislation and to really control the way the NCAA operates. And they move very slowly. That's just the nature of the kind of this bureaucratic beast that they've created, and somewhat intentionally so. And that's you've seen a lot of very slow-moving components, very slow-moving to respond to not even just changing times, but also, crisis and confidence about the NCAA's ability to function or their fairness. I mean, this goes back to pre-NIL when they had this iron fist over everything, and we're restricting how whether you could actually give athletes cream cheese on their bagel, whether that could be considered a meal. I mean, this all goes back to that, and I think the mistrust that we all have for the NCAA goes back to that. And I just don't think they've done it. I just don't think they've done it enough to rectify that, because every change they've made has just been forced on them.
Agreed. Guys, make sure you check out Sam. He is over at Sam C. Ehrlich or Ehrlich over on X or at collegesportslitigationtracker.com. Thanks for the couple hundred of you guys over on X, and thank you for those of you on YouTube. You guys have been great. Make sure you guys like the video, subscribe, share the thing out. I know I'm up late tonight again. Another Paul After Dark episode. We're pushing hard, guys, before the season comes to try to get you guys vamped up and ready for the season. And in this specific case, our West Virginia Mountaineers, I think, have the best chance of almost anybody to actually be ready for the season. What's interesting, I'm noting last year is seems like the judge is going to review all 4 cases simultaneously and then rule on them separately. Is that how it'll work? It's not a big yes or a big no, is it?
It'll be a big yes or a big no. It'll be all 4. It'll be none.
My gosh!
I can't imagine it wouldn't be, because these players, yes, their situations are different, their personal histories are different, but from the perspective of the antitrust claim, their claims are the same.
Wow. Okay. Well, that's news I didn't know about. I'll make sure to note that. Thank you so much for your time, brother. The mascot here says thank you as well. We'll have you on more, man. You're really good. Are you on camera very often? Well, you probably obviously in front of a courtroom a lot, right? In your life?
Not so much. I didn't spend a whole lot of time as a practicing attorney, and when I did, it was mostly behind a desk. But I spend a lot of time in the classroom now. So,
well, you're good on camera, man. Honestly, I don't know how often you've done this, but you did really well.
I appreciate that. Thank you.
All right, guys. Appreciate you for joining in. We're going to bounce out of here. I'm going to go make that sandwich we talked about after the last show. See you later, guys. See you, Sam. We're out of here.